The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Please be seated. All right, we're prepared to hear argument in Deal versus City of Monroe. Mr. Cadill.
May it please
When
the
you're
court.
ready.
May it please the court. My name is Bo Caudle, and my co-counsel Sophia Papalardo, and I represent plaintiff appellant Ken Deal. This court should reverse the judgment below and hold that the defendant, City of Monroe, violated Mr. Deal's due process rights when it removed him without cause, without notice, and without any opportunity to be heard from the city's Board of Adjustment prior to the expiration of his fixed statutory term. In concluding otherwise, the district court held that because the City of Monroe had the statutory authority to abolish its Board of Adjustment, that Deal had no legitimate entitlement and therefore no property interest in either his term on the board or his position on the board, regardless of the fact that the city had never actually abolished its board. And that's wrong. Section 160D-3.
Why would you address the abolishment? It seems to me there's an explicit statute that says it's at will, right?
No, there's no statute that says it's at
Ordinance,
no,
32201E.
there is an ordinance that the City of Monroe enacted, but North Carolina law is that if that ordinance is in violation or in contradiction to a state statute, that it is not effective.
Well, the state statute basically authorizes them to create the board. They may or may not create it. And if they create it, they should have 5 members having 3-year terms.
If they create it, as long as...
But then the city enacted an ordinance that said, we are going to have a board, 5 members with 3-year terms, subject to at-will departure.
So
That's what the ordinance said, right?
that is what the ordinance said.
Okay, and the question is it's pretty clear when he took that job, he knew he was getting a 3-year term that was subject to at-will dismissal.
No, that's not clear. The city...
What's the ordinance say? Tell me what the ordinance says.
That is what the ordinance says.
Well,
but
then why isn't that clear?
because there is a state law that says that the city cannot enact that ordinance as a matter of North Carolina state law. And that is how the North Carolina Supreme Court...
I thought the state law, you just agreed with me, was an authorization. It authorized the city to create a board with 5 members with 3-year terms. It didn't say impose any restrictions. It said basically 5 members, that's a restriction, and 3-year terms, that's a restriction. But a 3-year term doesn't mean that you can't put in provisions for how the term is fulfilled or whether you can release somebody. And just to put a little more substance on it, you cited a string of about 10 cases in your brief, and virtually every one of them said that an at-term is presumed to require for cause unless otherwise specified.
by the statute.
No, well, these terms are created by the city.
No, the city has no right.
The state didn't create the terms. The state authorized the city.
Your Honor, it begs the question whether the state statute authorized the city to vary those terms. That is the issue in this case, and that is what the North Carolina Supreme Court said in Board of Adjustment versus Town of Swansboro. The city was not free to do. What the North Carolina Supreme Court said is that this statute says that so long as you have a Board of Adjustment, they have to have 3-year terms, and those terms cannot be reduced.
You know, by with all these, creating all these property interests around you have a property interest in this and a property interest in that and a property interest in some things that seem to me involved in politics. But the upshot of it is that we are moving government away from democratic accountability by creating these property interests in office holding of some sort or another. And I'm not sure that that's a healthy trend, because you create a property interest here and a property interest there, and you've got litigation over this removal and litigation over that termination and all the rest. And you are taking government away from the people who in this case, it wasn't elected, but was appointed by elected officials. But the overall trend just concerns me that to extend Loudermill to the point of having virtually civil service protections for individuals whose the terms of whose employment has been clearly enunciated to them. But it just strikes me as an anti-democratic move. That's a problem. I realize this person wasn't elected, but it's clear what the terms of his employment were, and it was clear what the authority that was vested in elected officials. And to sort of extend civil service protections across the board to this kind of situation is an anti-democratic move. That's the problem, isn't it?
I think it could be a problem in some cases, but not this one. Because I think that with respect to boards of adjustment specifically, the legislature would have a very good reason to put a degree of separation between the Board of Adjustment and the democratic process, just as there's a degree of separation between the democratic process and the appointment of federal court judges, because the Board of Adjustment in North Carolina acts as a quasi-judicial board. And if those members can be removed at political whim, then you are sort of defeating their potential neutrality in any case that comes before them.
But you would agree that the Supreme Court in Swansboro, that there's this level of discretion. I mean, they said, we're gonna wipe out the whole board, and they said, that's fine.
They said
And so it seems as if, the way I read it, and also this court's precedent, if there's discretion, which it appears that there is, if there's discretion, then you don't have any entitlement to that seat, right?
I would quibble with that a little bit. I agree that the question is about the degree of discretion. I do not think that the fact that they have some discretion means that the state law does not place meaningful limits on that discretion. So in Board of Adjustment versus Town of Swansboro, the North Carolina Supreme Court said that yes, they have discretion to abolish the Board of Adjustment. But if they don't abolish the Board of Adjustment, then the members have 3-year terms, and those terms cannot be reduced. And so there is a limit on the discretion. Importantly, the city has said repeatedly in its briefing before this court that this decision to abolish the board is something that the city could do at any time. That is not true. This is important. Swansboro talks about this. In fact, if the city wanted to abolish the board, if it wanted to exercise its discretion to do that, it would have to publish notice, and it would have to have a legislative hearing, which Chapter 160D defines to mean a period of public comment. That is, it would have to give notice and an opportunity to be heard to the public, which
Maybe
includes...
so, but that's really a matter of at most state law, and it's a decision that the North Carolina courts or the Board of Adjustments can make. But if the North Carolina, as I read the North Carolina case, and particularly the Town of Swansboro case, if a municipality can abolish the Board of Adjustment altogether, that would seem to, the greater power would seem to subsume the lesser one about whether there was a termination in the middle of a term. And I just, in looking at the North Carolina cases like Mudd v. Ellington and the like, and it says, you know, that the basic proposition here is that the sovereign owns public offices, not the occupant. And that's exactly what I thought the town of Swansboro case was indicating. And for us to go creating all of these property entitlements, we're charging right into the middle of North Carolina law. I realize property entitlements under the Roth decision are created by state law, but there is still a federalism interest here. And not in view of the town of Swansboro, I don't know how we can go charging into the middle of North Carolina law and say, well, yeah, we understand you can eliminate the Board of Adjustment altogether, which would by definition eliminate people's terms in short of 3 years. And to tell North Carolina that they essentially can't do that, or that their property interest involved here, seems to me to begin to take over intrude upon North Carolina governance to a questionable extent. I'm just sort of, if they have the power to eliminate the Board of Adjustment altogether, why don't they have the power to curtail the terms? I mean, it would assume the greater power subsumes the lesser one.
There's quite a bit to unpack there. I have 3 responses. I'm going to try to get through them quickly. The first is, I don't think you're charging into North Carolina law. We're not writing on a blank slate here. You're not creating a property interest. We're not asking you to create one. The North Carolina Supreme Court in 1993 interpreted this language and said that you cannot reduce the terms of a member of a Board of Adjustment so long as that board is in existence. That is a paraphrase, but it is pretty close to the exact language that they used in the opinion. The second point that I would like to make is, with respect to this idea that the power to abolish the board means necessarily that we can't have any entitlement to the seat. If that is true, then we would also have to say that, for example, Congress's power to abolish the Federal Reserve means that no person on the Federal Reserve.
I really, with all respect to you, I don't think this has a whole lot of impact upon the Federal Reserve.
Well, respectfully, I think that it's the same conceptualization. If Congress can abolish the Federal Reserve, if it has that power, and it does, everyone would agree that it does.
No.
Well, that would be, we're talking about statutory, which is similar to what they said in that Frank's case. The difference, I think they North Carolina distinguishes Swansboro from Frank because they say these are statutory agencies. There's a statute, they talk Department of Social Services, what was the other ones? The Department of Election, which means these are statutory, so it takes once again away that discretionary. Here, it's the same thing. You have discretion. The board has discretion. The city has an ordinance, as Judge Niemeyer said earlier. I'm not sure this case lines up with Swansboro.
They have discretion to do a certain thing, which would be to through a public notice and comment period, decide to abolish the Board of Adjustment. They do not have discretion to have a Board of Adjustment and to appoint members to less than 3-year terms.
Let me ask you something. I'm wondering why we're having this debate as to whether the city ordinance is legal under the state law, because when this man took his job, he took it with the ordinance in place. He took it for a 3-year term, which would end his term unless he were terminated at will during the term. He took it with that knowledge. Now, the question is, if that's the job he took, where did he get a property right? I mean, the ordinance was in place, and you're challenging the ordinance, but what he actually got, we're talking about whether he got a property interest. And he clearly took a job which had a 3-year term subject to at-will termination. And he knew that when he took it, and I don't understand how he somehow got a property interest on a future argument that the ordinance somehow violated state law.
So the flow chart would go like this. There's an ordinance. The ordinance says you serve at the pleasure of the city council. But problematically for that ordinance, there is a state statute that has been.
I know, but when he took the job knowing the ordinance was there. The ordinance was in place. Whether it was legal or not, he didn't make a determination that that ordinance is illegal and I'm going to take the job. He took the job under the authorization of a city ordinance which provided at-will disposure. So the question is, when he took that job, whether the ordinance is legal or not, he took a much lesser interest than you're asserting. He took an interest in a 3-year term subject to termination.
So if I'm understanding the question correctly, it's almost like we're saying that his subjective belief about what the job entailed would dictate.
No, it's what his property interest was. In other words, we're talking about you're talking about a 14th Amendment taking of property, so to speak. And the question is, what did he get? And the ordinance was in place, and he was appointed under the ordinance. He was not appointed under state law. He's appointed under the ordinance authorized by state law. And you can argue that the ordinance is illegal, but what he actually took was a job subject to termination. And he knew that. So now how does that circumstance, an appointment under that ordinance, give him a property interest?
I think where we disagree is, respectfully, is that I don't think he was appointed under that. The ordinance was illegal.
That's the only authorization they had. The city had the authority to appoint him, and they appointed him under the ordinances. Your argument is that the ordinances are illegal now, but that doesn't affect what position he took.
They were always illegal. And it would be like if I was testing let's say there was a city ordinance that said that I cannot insult a police officer, and then I insult the police officer. When I come before the court's not going to say, well, at the time the ordinance was in effect and you insulted a police officer. The court's going to say that ordinance is a violation of your First Amendment rights. It is void and of no effect. And the same principle applies here. If the state law that authorized.
Well, you're arguing that he clearly was appointed under the ordinance, but you're arguing he was appointed under an ordinance that was partially had to be ignored.
Yes, that's right. Because.
And so this is at the appointment stage, even though at the appointment stage, the full authority that appointed him was the ordinance.
That's right, because we argue that that ordinance, by imposing a minimum term in office, requires a for-cause protection. And that's the principle we derive from the cases.
Did he make an objection to the ordinance when he got appointed?
No, Your Honor, but I don't think that is how, again, I think if there's.
We're talking about whether he had a property interest. We're not talking about the legality of an ordinance when he's appointed.
But
he was appointed under an ordinance that did not give him a property interest.
But respectfully, we decide whether he has a property interest at all by reference to state law. And the state law was that the authorization of the city was to create a board of adjustment with individuals with minimum terms in office, and to give that any meaning at all. They can't be removable at the whim of the city council.
All right, I think we've gone over there. Thank you very much, and you've reserved some rebuttal time.
Thank you, Your Honor.
Mr. Bader?
Good morning, and may it please the court. Stephen Bader here on behalf of the City of Monroe. This court should affirm summary judgment for the City of Monroe and decline council's invitation to extend constitutional tenure to members of a local discretionary board.
One thing I just mentioned to opposing counsel, I realize that under the Roth decision that property interests are a matter of state law. But that doesn't eliminate all the interest in federalism that I see, because that doesn't mean that, I mean, in some instances, it's advisable when we're talking about creation of entitlements to state government, that some instances a certain level of deference is required, and say, if these entitlements are going to be created, it's probably better for the North Carolina courts to do that. And he says, town of Swansboro already did that. I don't think so. But all I'm suggesting is that simply saying that entitlements or property interests are a matter of state law doesn't eliminate the interest in federalism, that federal courts are going about creating entitlements right at the heart of state government. And that's, you know, there have to be a question, is this the road we want federal courts traveling? To be creating entitlements, this and that, and this, right in the middle of state government.
Yeah, Judge Wilkinson, I agree with that, and I think that's, you know, Swansboro was not a constitutional case, but what the court did there is it said, here is what the North Carolina General Assembly has given our local governments the ability to do, the discretion to do. And then they made a determination as to how that comes about. And you're right, for the federal court to say, well, we're going to take that decision that didn't even deal with property interests and contort it in such a way as to find a property interest certainly does create some problems from a federalism standpoint, you know, and probably others. Judge Benjamin pointed to the Franks versus Savage case, and that case is a good example of how North Carolina state law can create a property interest in a local government position. But in that case, you had a social services board that, number one, was mandated by North Carolina state law. The statute says that a county shall create this board. Number two, it says that members of that board shall serve for 3 years. And number three, it said that the county cannot change the composition of that board once it is created. And so the North Carolina Court of Appeals, in reconciling that statutory structure, said that creates an arguable property interest. And then in doing that, it distinguished those statutes from the Board of Adjustment statute discussed in Swansboro and said that is a permissive statute. It says that the county may create a board. It doesn't say that it shall. And the corollary to that is statutes that use the term shall arguably create that interest, while Swansboro, by distinction, does not. And the dicta in Swansboro that my friend refers to, really what it's talking about is the structure of how these boards are set up. They have to have at least a minimum of 5 members, and I would correct Judge Niemeyer just a little bit. This board actually has 7, but it's a minimum of 5, and then they're 3-year terms. But the very next sentence in the statute, 160D-302, actually gives the board, or the city, greater discretion in appointing new members or members to fill terms, to say you can actually do it for less than 3 years, so that way everybody's not coming off at the same time. But that is structural to the board. That does not create a property interest in an individual member that occupies a seat. If that was the intent of the North Carolina General Assembly, this statute would read very differently. It would use the term shall somewhere, and it doesn't use the term shall at all. It would mandate that members of this board must or shall fulfill their terms. It doesn't do that either. And it would put some kind of a framework in place for how cities or local governments could remove members of that board, similar to how they treat boards of social services, boards of election, other boards like that North Carolina General Assembly has elected to impose more restrictions on how they're formed and how they operate. That is just simply not true of boards of adjustment.
Counsel, you've written a good brief, and I think we understand the arguments that you've made in your brief, as well as the arguments that you've made before us. At this point, I'm going to ask if my good colleagues have additional questions for you. Otherwise, we've heard what we need to, Paul. We're fine. Thank you very much.
Thank you very much, Your Honor.
All right. Mr. Cadill?
Thank you, Your Honor. First, the language in Swansboro that I cite is not dicta. I think it is central to Swansboro's holding. The question in Swansboro was, what's the proper interpretation of 160D-302? And Swansboro says, this is the proper interpretation of 160D-302. You cannot remove a member, or you cannot reduce the term length of a member so long as you have a Board of Adjustment in place. The statutory language at issue here does not allow for the variability for appointees other than original appointments or replacement appointments. And that's significant, that language in 160D-302A. Because if it were true, as the city suggests, that they can essentially do whatever they want with their Board of Adjustment, it would be completely unnecessary to include that language. Also important is if you look to the very next statute in that same article, 160D-303, the legislature, in appointments to the Historic Preservation Commissions, says that appointments shall be for a maximum term of 4
Why should we be the ones to untangle all of this business? Why wouldn't why wouldn't the creation of entitlements within the heart of state government itself, or within the heart of local government itself, which would be subject to the authority of the state, why should we be the ones to create entitlements here and there at the heart of state government and at the heart of local government? I don't think you're right in the way you read the statutes, but you may be. But if that question is going to be resolved, isn't there some value in allowing the creation of state employment entitlements to be made within the state itself? It's their government. We're not talking about classic property interests in terms of a 4-acre lawn or whatever it is. We're talking about employment, state employment entitlements at the heart of state and local government. And you've argued one way and they've argued another, and it's a tangle. But why wouldn't state courts, why wouldn't there be an interest in this sort of marginal situation of having the state courts? I can't do it.
So if you disagree with me about what Swansboro did in 1993, then I can understand the position that federal courts should not rush into it. But I don't think that there is any way to read Swansboro other than that Swansboro interpreted. I see my time is up. May I briefly conclude?
Yeah. Thank you very much, sir.
Okay. Thank you very much, Your Honor.
Your company under recounsel, moving to our next case. Would you please come and introduce student council to us?
Good morning, Your Honors. If it pleases the court, Aderson Francois, Faculty Director for the Georgetown Law Center Civil Rights Clinic. And I'm introducing student counsel Kylie O'Donnell, who will be presenting argument for the appellant this morning.
All right, we thank you very much, and we're pleased to have you here.
Good morning, Your
When you're ready.
Honors,
Mhm.
and may it please the court. The district court erred as a matter of law, and its judgment should be reversed for 3 reasons. First, officers violated the Fourth Amendment when they entered Professor Hyatt's home without a warrant, without probable cause plus exigent circumstances, and without reason to believe that their entry was direly needed to render emergency aid. Second, the district court wrongly assumed that retreat from a Terry stop is a per se exception to both the warrant and probable cause requirements. It is not. But third, even if it were, there was no Terry stop in this case. Officers never made a valid show of authority and lacked reasonable articulable suspicion. A person's home is afforded a first among equals status under the Fourth Amendment. Without a warrant, search and seizure of a home is presumptively unreasonable.
But was this a search and seizure of a home, really, when the reasonable suspicion was formulated or was found outside of the home?
Your Honor,
I mean, it's a different situation of where there's no connection between what immediately was seen outside and what the search took place within. I mean, normally you have a situation where you apply for a warrant, and you do so, and then you simply go in and conduct the search. But here, it's part of a sort of a continuous train of events, is it not?
Your Honor, there was not reasonable suspicion in this case. So I'm happy to speak about that issue first.
Let me ask you just about that. Assume with me that this was a kidnapping and these children were being abducted and taken away. Within a half hour of the report, the parents came forth and said, our kids have been stolen, and everything else is the same. Your argument is that when the defendant closed the door, the police should have just walked away and gotten a warrant.
Your Honor,
In the meantime, the kids would have been taken, hidden, removed, and this is private property. The police can't come there even though they have information that there was a kidnapping. What should the police have done, and under your proposition?
Your Honor, taking your hypothetical as on its face, as you described, officers in that situation may have had an objectively reasonable basis, as the emergency aid doctrine requires, to enter the home for the purposes of rendering emergency aid to children. But that hypothetical is distinct from the facts of this case. This case,
my hypothetical, the only difference was that this was turned out to be a real kidnapping as opposed to one that was reported by the informant. And so we can go there if you want to talk about that, but it seems to me the police are not in a position to assess all that. They questioned the reporter about the details, and the reporter explained what he saw and got the license plate number and all that and told the police. Now, the police could say, I don't believe it, and of course, at that point, we have kids that are lost. But the police have to take it. They found it credible. There's a lot of corroboration that made it credible. And I'm not sure what you want the police to do. I mean, this is a very serious crime if it were occurring. It turns out in this case, it wasn't occurring, but I'm not sure where you want us to go on this. They walk up to the front door, engage in a conversation, and of course, that conversation is very, very awkward. I watched it several times on tape, and it seems to me if these people were, Terry stop is conducted to allay suspicion. And it seems to me when they went there to question the defendant, their suspicion wasn't allayed, it was heightened because of the refusal to answer questions, refusal to come forward, and then slamming the door in the middle of a sentence. And so I think you got to sort of take the other side and see what does the public expect of the police when they have that kind of a report.
Judge, to the point of your hypothetical, the factual distinction between the hypothetical in this case is that there was no report from parents that children were missing.
No, this report came from a witness who saw, let's say he just saw a little bit more. He maybe missaw, but he reported, he was very concerned. He concerned enough to take the license plate down. He witnessed the kids, they were screaming, they were thrown into the trunk. He said they were tied up, and the person went away, and he tried to catch the license plate. Now, it may have been innocent, but it also may have been a serious problem. And your whole argument would have put handcuffs on the police that they just couldn't have explored that suspicion.
Your Honor, we disagree with that. Officers'
Let me ask you this
position-
before you start.
Yes, of course.
And I know we're at the summary judgment stage, but isn't there a question of fact? My understanding is that there was a anonymous tip. In that anonymous tip, no one used the word kidnapping. And they followed up on the tip. Somewhere in translation, dispatch said kidnapping.
Yes.
They go to the IHOP. They speak to, I think his name is Solano.
Yes.
And Solano says that this man is in a Tesla. He gives them the tag number, and he put the kids in. I don't know if he tied them up. I don't remember it saying tying up or let me say this. There's a question of fact as to whether there's some tying up or if it's throwing. My understanding is that the testimony that we know is that the kids were placed in the back of a Tesla, and it's a trunk, and we know that the police officer says, Morano, I believe is his name, that Teslas have rear-facing seats,
Correct.
and that is legal.
Yes, correct.
Okay, so I'm not sure that the facts here are similar to what the hypothetical that Judge Nehemiah just stated. And am I correct that those are all disputed facts?
Yes, you're correct, Your Honor, that those are the disputed facts in this case, and that when officers arrived, they were operating off of a tip, and what they knew was that there was a black man who was seen putting children in the back of a Tesla, and that a Tesla had legal rear-facing seats. When they arrived...
I don't quite understand your response to that question. You say it was disputed. The officers didn't dispute the report, and they didn't dispute the information they received. They explored it. They ran it down. They got it from a second-hand witness, and then they got the first-hand witness. They got the license plate number. The officer spoke Spanish to the person and said what he said, and he actually used the word tied up, and according to the officer. Now, it may not be right, but that's the information the officer had. Now, what's the officer supposed to do with that information? It's not disputed.
Judge, officers should have investigated and developed an objectively reasonable basis. They could have gathered more information about what happened at the IHOP, what might have been occurring in Professor Hyatt's home.
And in the
They could have
meantime, the
staked
kids
out
are
the
gone,
house.
right?
They could have, no, Judge,
You're
they,
giving second question about the type of investigation the police should be conducting. But I gather you agree the police are entitled to investigate and pursue that. They now have reasonable suspicion that something's going on.
They are entitled to investigate, Judge, but I would point you to Case v. Montana, which says that the emergency aid doctrine is not about criminal
I'm
investigation.
not talking emergency aid, I'm talking about Terry stop, reasonable suspicion.
Well, to the point of reasonable suspicion, I would point you to Massenburg and I would point you to U.S. v. Black, both cases from this circuit. In Massenburg, the circuit said that an officer cannot turn normal responses into suspicious activity. And in Black, this court said that officers cannot patch together innocent suspicion-free facts that can't rationally equal suspicious activity. What officers saw when they arrived at Professor Hyatt's home was a man standing on his rights. He calmly engaged with officers. He asked them what they were there for. They said to investigate a kidnapping. He calmly responded that there was no kidnapping here. At that point, he then said, "What do you intend to do?" Officer said, "Can we see the kids?" He chose not to subject his children to a late night encounter with police, and it's his legal right not to have. And at that point,
He
he
had a lot of
said,
legal rights, but the officers had a right to allay suspicion. And the man
Certainly,
wouldn't
Judge.
answer questions. He wouldn't let them see the kids. He wouldn't explain. He didn't explain anything about what he did. He said simply his only response is no kidnapping here. And then he refused to answer. And when his wife started to talk, he said, "Get inside, Noreen," whatever her name was, and he then closed the door. I don't know if the police just walked away at that point saying, "We have no right to do anything further." I don't know what would have happened with those kids if those were real kidnappings. I think it would have been a dereliction of police duty, I would think.
Well, Judge, if we're talking about reasonable articulable suspicion, the home is protected by more. The home is protected by probable cause plus exigent circumstances. And we know that from Peyton and Kirk v. Louisiana. So even if officers had reasonable suspicion on this record, they didn't have a basis to enter the home. Defendants argue that pursuant to a Terry stop.
Familiar with Justice Brennan's opinion in Warden v. Hayden?
Could you describe that further to me, Judge?
It talks about hot pursuit, and that is when you're talking about either reasonable suspicion or probable cause, and that's formulated outside the house. And here, the activity that furnished the suspicion or the probable cause, we could debate that, was formulated outside. But this opinion and others seem to indicate a basic principle that where suspicious activity takes place right outside, and then someone retreats into the home, you can imagine it extending to all kinds of situations in which someone could likely to commit a perfectly heinous crime. That obviously didn't happen here, but someone could commit a perfectly heinous crime and then go and lock the door and say there's nothing you can do. And Judge Niemeyer points out the kidnapping young children, and we all know that didn't here. This was a family situation and a perfectly natural one. But kidnapping young children is about as horrible a kind of thing as anyone could imagine. And do we want to put barriers, concrete barriers in front of the police in investigating something where delay may mean somebody scooted off with the children? I mean, there's a way of looking at this, and that is you can be appreciative of the fact that the police cared about it. I know this was an unpleasant situation. I know this was a very, very difficult situation for everyone involved. I like to think, though, that people might be appreciative of the fact that officers were concerned about the welfare of their children. That's a good thing.
Officers obviously serve such an important public function, Judge, and we do not dispute that at all. But the home is protected by probable cause of a crime. And to say that
aren't there-
officers could enter on less would
Why aren't
undermine
there-
the warrant
Why aren't there
requirement.
exigent circumstances here in this sense? That if someone's going to kidnap very young children, they want to do it quickly. And a lot of times, in order to receive some ransom or whatever they want to do, they're likely to want to make a quick getaway or to do whatever they're doing quickly. I know I would be, I can understand why the homeowner here would be very upset, but I can also understand it from the standpoint of society needing to make sure that we don't put too many barriers in the form of extensive litigation to police who are looking after the community welfare and trying to protect the public's undisputed interest in the welfare of young children. That is my problem. I don't want to introduce too many inhibitory factors in a crime such as this. And I don't underestimate, I mean, as the father of those children, I would have been upset too. I can understand that completely. But I can also understand that society has a special obligation to look after its young.
Of course.
Wasn't that what happened here?
Judge, I see that my time has concluded. May I briefly answer
You
your
sure
question?
can.
Thank you.
You sure can.
I have 2 points in response to that, Judge. The first is that under the emergency aid exception, the Supreme Court has been clear that a community caretaking exception does not exist. So that goes to the criminal investigatory context. And the question is, what officers needed to enter the home in this case? And to say that they could enter on the undisputed record here would be to establish a categorical rule, essentially, that anytime someone is accused of a kidnapping, which is a serious crime, that officers could enter their home, but that defies the totality of the circumstances analysis that the
Can I
Fourth
ask you one
Amendment
question?
denied.
I know, may I
Yes,
ask
Judge.
one question? Yeah.
Of course.
I'd like to understand your principle, and you can just answer this as a matter of law.
Okay.
If the officers are conducting a Terry stop in the street, they have reasonable suspicion to stop somebody, and they start asking a few questions, and before they get to the third question, the person they suspect of committing a crime runs into the house. Do the officers have to walk away then and get a warrant? Is that your position?
Our position based on those facts, if reasonable suspicion did not develop into probable cause, yes.
It did not develop. It's a,
They would have needed to get a warrant, and I would point you to Kirk v.
so
Louisiana
that every
for that
Terry stop,
proposition.
when somebody runs from the Terry stop and then goes into a home, they can get sanctuary from the officer who has a reasonable suspicion and has not been allowed to allay his suspicion. That's your position?
Judge, yes, we know that the home is protected by probable
I
cause.
understand that.
flight,
I just want to know if
of
that's your
course.
position, that the Terry stop cannot be continued.
Yes, Judge, that is our position. And we would point you to Kirk v. Louisiana for that proposition. And we would also point you to Lang, in which the Supreme Court said that exigency is a closed set, and it is want to extend those exceptions to the warrant requirement further.
We've taken up between Judge Niemeyer and myself, and I plead guilty to that.
Good amount.
We've taken up too much of your time. Do you have some concluding comments that you would like to make? I want to make sure that you get your argument out.
Do we have time for rebuttal still, or do we think that that's
Well,
not
no, this
necessary?
is,
Just for now?
I'm just encouraging you to give us some concluding comments, and you've also got some time for rebuttal, but,
Okay.
I'm a guilty party. I've taken up a good bit of your time, and I shouldn't have done that, so go ahead.
Thank you, Judge. I appreciate that. Basically, Your Honors, this case comes down to what officers need to enter a home, what level of evidence. We know that retreat into a home stands at the core of the Fourth Amendment, and that the home is afforded the utmost protections, and that is the one space that the Fourth Amendment was articulated to protect. And the Supreme Court has been very clear on what officers need for home entry. In the emergency aid context, it's necessary, they have an objectively reasonable basis to believe their entry was direly needed to render emergency aid. Based on the facts of this case, officers did not. And in the criminal investigatory context, they need probable cause plus exigent circumstances. Neither the district court nor defendants argue that there was probable cause here, and we know that exigency is a closed set, and it does not include retreat from a Terry stop.
Thank you very much.
Thank you.
You reserve some time for rebuttal.
Thank you, Judge.
Mr. Ramirez, we'd be pleased to hear from you, sir.
Good morning, Your Honor, and may it please the court. My name is Aaron Ramirez, and I, along with co-counsel Kristen Nunley, represent Sergeant Diaz and the other appellees. We would ask that this court affirm the district court grants of summary judgment in favor of the appellees for 3 reasons. First, the district court correctly held that Sergeant Diaz lawfully initiated a Terry stop in this case for an encounter that began outside of the appellant's residence and was based on reasonable suspicion. Second, entry by Sergeant Diaz was also permitted.
What's the reasonable suspicion?
The reasonable suspicion, Your Honor, begins with the call itself. The call was for a priority call from dispatch indicating that there was a report for a kidnapping.
Was there, but the tip, the anonymous caller didn't use the word kidnapping.
So
That was dispatch, right?
So dispatch coded it as a priority based on the information relayed, dispatch coded it as a kidnapping based on the information relayed by the first anonymous caller, as you described him. We actually know that caller's name. That caller's name is Luis. And it is important to clarify, I think, for the record, that there are 2 individuals involved where the police are getting information. Mm-hmm. The first is Luis, who actually makes the phone call to 911. However, Luis did not make these firsthand observations. That was Mr. Ayala Solano. So Mr. Ayala Solano was the actual person there who witnessed this event that, as the court has already noted, was so concerning that it actually caused him to write down the tag information. And he was still there, present, at the IHOP when Officer Moran, I think the court alluded to him earlier,
But
was
when
there for
Morano gets there, he says that he puts the kids, this whole thing about throwing kids, tying them up. Solano doesn't say that. Would you agree?
No, I do not agree, and I'm glad you've raised that point to clarify that for the record. So we have the benefit of Officer Moran's deposition testimony, and in that deposition testimony, and we also have the benefit of the actual radio transmission itself that was overheard by Sergeant Diaz en route to the residence. But to answer the tie up the children question, that was relayed to Officer Moran by Mr. Ayala Solano on the scene. That is in his deposition.
But it is disputed.
What is disputed?
That there was this other than the officer, there's this dispute as to whether or not that Solano said that to the officer.
No, I don't believe that is disputed because it is a deposition under oath, and the only 2 people that were witnesses to that conversation would be Mr. Ayala Solano, the reporter, the first party, the eyewitness reporter, and Officer Moran. And we have, as part of the record, the under oath deposition testimony of Officer Moran that says that Mr. Ayala Solano told me that the children were tied up. And that is as part of the joint appendix.
And he also says that he told him, he says he put him in the back of the car and was yelling at them, right?
So
he put him in the car and he was yelling at them. And then he says, Morano, not Solano, the eyewitness, says, well, a Tesla has rear-facing seats, and that is legal.
So the complete transition, and and I think there's a point of clarification in Your Honor's recitation of the facts. The radio transmission from Officer Moran, overheard by Sergeant Diaz, is as follows. I have the original complainant here. He says he was at the IHOP in Langley Park, and he saw the black male open the trunk, not the vehicle, the trunk, yell at the kids, and then close the trunk. But like I said, they might have possible rear-facing seats. So
Okay, so what part of that, because this is what's happening at the time over dispatch, right? Where do you get in there that he said that he tied him up
So-
And he told them that over dispatch. I understand what was said at the deposition.
Correct.
But this is an objective standard, so what he said at the deposition is after the fact. But over dispatch, he said he put him in the car, and he yelled at him, and he closed the trunk.
Correct.
So what part of that at the time is kidnapping?
So there's two things at issue here in terms of the facts. There is what was relayed over the radio and overheard by Sergeant Diaz, but there was also the corroboration element, because I think that's one of the questions that the court had earlier was, how is this being corroborated as a kidnapping? Because kidnapping is the words of the dispatch interpretation, right? And so how do we know that that is correct based on what the eyewitness said? So when Officer Moran responds and actually interviews the reporter, the eyewitness, he gets all of this information. He doesn't put, I agree with you.
This is what he says. He says, so the gentleman was speaking in Spanish, and he stated that he witnessed a gentleman come out, open up a trunk, tie up children inside, yell at them, and slammed and shut before driving off. That's what the witness told Officer Moran.
Yes, I think you're reading from his deposition.
His deposition, but
Correct.
over dispatch, at the time of the incident, that is not what he said.
So I agree with you that the tie up the children was not put out over dispatch, but those are two separate issues. What was put out over dispatch is the information that is available to everyone to hear. But I believe your original question is, how can the police conclude, how is dispatch correctly concluding that this constitutes a kidnapping? And the answer lies in what Judge Niemeyer just said, which is Officer Moran's purpose to go and interview this first reporter is to actually verify, okay, are we understanding this correctly? So he gets additional information that includes the tying up of the children. Although that isn't put out over the radio, I agree with you, that still corroborates the description of a kidnapping.
So you don't think that it would be important for him to say, because he says it's in his deposition sometime later. You would agree, right?
Yes, I agree.
So if there is a kidnapping and kids are tied up and thrown into the back of a car, he just left that out from telling dispatch that. So that would not be important to tell dispatch on a suspected kidnapping.
Well, I can't speak to the decision-making that Officer Moran made at the time.
Because this is an objective standard. He says over dispatch that there is a Tesla and that there are kids that are that he put in the back of the car.
Correct.
He's yelling at them and he closes the trunk. And the officer offers, not the witness, that some Teslas have rear-facing seats.
Yes, they might have rear-facing seats. I think you have stated correctly, Your Honor. I think the record, your statement of what was put out over the radio is consistent with what you've just said.
Let me ask you two questions. Did you interpose any kind of defense of qualified immunity here?
We did.
Okay.
I'm
not sure you knew, I know you're not giving away your argument that there was nothing incorrect about this.
That is correct, Your
I just
Honor.
want to know, as a matter of fact, you interposed qualified immunity.
We have. That is so as I was noting earlier, entry to the residence there were 3 grounds for affirmance in this case. The Terry stop was correct. The entry was permitted under emergency aid, and third,
Right.
qualified immunity.
I understand.
And so, sorry. I
The
apologize.
other question I had was with respect to to Judge Niemeyer's earlier question. And Judge Niemeyer said, what do you expect to do? What would you expect the police to do? And if we were to reverse here, wouldn't we come close to creating a rule that the only thing that the police can do in the face of very suspicious, in the case of suspicious circumstances, is simply to walk away?
I think that's exactly what this court would impose.
And is that the kind of rule that, in the long run, is going to protect children and all kinds of victims of crime, to saying, when faced with this, and the circumstances here that I think rise to the level of exigent because of the speed with which kidnappings and abductions occur, Do we really want to communicate that the only option the officers have is to walk away, formulate an affidavit for a warrant, see if they can get a magistrate approval, and at the end of it all, the children are long gone? And is that the rule that emerges here? I mean,
Your Honor, not only is that not the rule that emerges here, but in two cases heard before the circuit and affirmed before the circuit, which are both Harbin and Rivera, this court actually has affirmed situations where a Terry stop encounter begins outside of the residence.
Well, now, you know, in Riviera, they were in the parking lot of the apartment complex. This man is standing in his front door. And so you don't think that's different? He's standing in his front door, they're investigating a domestic dispute, and they tell him, do not move. That's not the case here. He's seized at the time in Riviera.
So while I agree that in Rivera that command existed, I do not think it's as dispositive and certainly not part of the rulemaking as has been interpreted this court.
But what here tells us that they were seized at the front of at the door where they could not go back into their house?
So I'm happy to clarify this, and I think this was actually already stated by the court previously, where someone indicated that this was a continuous encounter, and that's exactly how we view it. So from our perspective, and I want to clarify this because I don't think there's an argument that we've conceded in the brief. We have not. I would point the court to page 14 of our brief, but I'll state it concisely here. The Terry stop was initiated the moment that the appellant cut off the conversation with his wife and turned around to walk away, and Sergeant Diaz, in response to that.
So that's when he was supposed to know that he was seized?
The moment that Sergeant Diaz began to follow him, taking steps to follow him to prevent his reentry, that overt act by Sergeant Diaz to follow him is the initiation of the Terry stop.
Well, so that's the initiation of so the Terry stop is not when they arrive at their house, because the car is not even there in the yard. So you're saying once he enters the house, that's the Terry stop?
This court can look back temporally at any point in the conversation to deem where the Terry stop began. However, it is our
But no, you're saying your position is that the Terry stops once he once he entered the house.
No, my position is that the Terry stop was initiated once the investigation was cut off, and at that point, Sergeant Diaz takes the affirmative step to detain by walking up behind and seizing the appellant at the door. And
He didn't seize him at the door. He pushed and opened the door behind him.
Yes, that is correct. But all of this, as was stated earlier, is all one continuous transaction.
Okay, and let me ask you, what in terms of reasonable suspicion, because you make this argument that he was not cooperative, right?
That's not how we phrased it, no.
Okay, well, how do you phrase it?
So-
As to your reasonable suspicion, since your Terry starts at the time that he pushes his way in the door.
So I think there's some, there is an encounter that happens outside, right? And this is a conversation, this is clearly an investigation, right? And I want to sort of take a moment to step back so that I'm not mixing standards here and mixing phraseology. This encounter clearly begins outside. It is clearly a criminal investigation. This is articulated from the outset, right? I think what the appellants are saying has to happen is that there has to be a, quote, show of authority in order to continue into the home. That is not stated in Harbin. In fact, the facts of Harbin are completely different than that, and that is not stated in Rivera.
So you're saying it does not have to be a seizure for the reasonable, because you're saying under the Terry stop, I mean, how does he know that he is not to leave?
He's not,
Because in Riviera, they told him you are not to leave. He took off and ran, and that's why the court said he was seized. He took off and ran. You have the right to go in the house after him.
So I disagree with you that the court in Rivera said he was seized at the point of the command, because the case law, I think, is very clear that a show of authority or a command that's disobeyed is not a seizure. And I think that's clear. But I will answer that question, I think, best by pointing to the facts of Harbin. Because in the facts of Harbin, which were later affirmed by this court and that opinion adopted by this court, the two officers that end up seizing the Harbin suspect after he has crossed the threshold of the home has no awareness whatsoever that the police are following him. I think the appellants have misread the facts of that case. In the Harbin case, there was a report of a gun at a 7-Eleven. 30 minutes earlier, 2 different officers follow another man with a gun. The 2 officers that stop Harbin find Harbin in the street, follow behind him a distance of 15 to 20 feet. And it is only after Harbin crosses into his house do they announce themselves by commanding him to stop. So those facts would mirror our facts to the extent that Your Honor thinks that it wasn't clear before.
The gun, I mean, what is your reasonable suspicion here, though?
So the
He
reasonable-
says, he tells them, if you would like to enter my house, you have to get a warrant. So him asserting his constitutional rights is leading to reasonable suspicion?
The fact that a priority kidnapping call was put out, that the eyewitness was interviewed who confirmed.
Okay, so there's a kidnapping call, right?
There's a kidnapping
All
call.
right, so normally with the it's a kidnapping call, it's an emergent situation, right?
Yes.
Is there an Amber Alert put out for the call?
To my knowledge, no.
All right, they show up, but there's sirens?
And that is specifically, there were specifically no sirens or lights used to not
Is there a
trigger-
bolo put out over dispatch from, I mean, none of these things say that there was a kidnapping.
So I would disagree with you on the fact that none of these things say with the kidnapping. And I don't know what the court means by a bolo, but a priority call was announced over the radio for all officers
What I'm
to
saying
hear.
is they had the tag,
Correct,
I mean, from the very beginning.
correct.
If they thought it was a kidnapping, they had a tag from the very beginning.
Yes, Your Honor.
They take the time, they go to the IHOP, they interview the witness, and then they go, he puts it over dispatch to Diaz. Morano says he put him in the back of the car, he yelled at him, he closed the trunk. That's what Diaz knows at the time, right?
So I would disagree with the court that these things are happening sequentially. These things are all happening at the same time. Sergeant Diaz is en route while Officer Moran is performing the investigation, which speaks to the speed with which the call and the response is happening.
Well, the Telsa obviously does have arrangements to have seats in the rear, but the normal place for children to be seated in a car is not in a trunk.
That is correct, and I would
I mean,
also,
that's just a pretty basic fact, that normally when we put children into a car, they're, most often if they're young children, they're in the back seat of the car. Maybe occasionally they're in the front seat, but normally in the back seat. But the one place that they are not, normally, they're not pushed into the trunk of a car.
correct.
That is not where children are normally placed.
I would agree, Your Honor, and I would also highlight the fact that the information that was put out with respect to rear-facing seats that were, I guess, appears to be unique to
This
Teslas.
might have been a different case had the children been, I mean, frankly, we all yell at our children sometimes,
Sure.
at least. I think we all do. I mean, children can test your patience. But this would have been a different case, would it not, if the children were being placed in the back seat and they were upset about it and didn't want to be in a car seat or what have you?
I would agree with you that we're looking probably at
You're
this
looking at
circumstance somewhat differently.
You're looking at a dramatically different case. And the salient fact, one of them is that they're not being placed in the back seat of a car. They're being put into the trunk. And normally, that's not where children are placed in. That's, I mean, it's not the only fact. There are other surrounding facts, as you put it, in the course of a continuous transaction.
Correct.
But it starts there, does it not?
I believe it absolutely starts there, and I think.
But doesn't the officer, he himself says,
Answer my question.
and go ahead and answer this question, but.
I believe if I remember the question, it was, I'm now forgetting the question. I believe the question was asking, doesn't it begin there with the report of the kidnapping? And I would echo I believe it was Judge Niemeyer's comment that the observations of this witness, what they saw was so concerning that they actually took affirmative steps to write down the tags and alert the police. They were even still there waiting. They were still present on the scene for the police to interview them. And I think those are all significant facts that only hearken the beginning of the police's investigation. It is not the beginning and the end. And as was also pointed out, we have the entirety of the conversation and the benefit of knowing that Sergeant Diaz purposely turned off his lights and sirens to not alert his approach to the residents for his investigation. Yet there, seemingly doing nothing else, the appellants are standing there not engaged in any other visible activity other than seemingly expecting his arrival. And so every subsequent part of the investigation only furthered the observations of the officer that the appellant did not want to, he wanted to disassociate
I found
himself.
that very curious that they were standing there. Is there anything in the record to suggest that they may have had information about the complaint? In other words, the fact that both the defendant and his wife were standing on the porch sort of as the officers approached is peculiar, isn't it?
I agree it's peculiar.
I couldn't
and it's-
figure out why they were out there on the porch as the officers approached, and I was just wondering, is there any indication that this information was known to them or broadcast in any way, or?
I see that my time is concluded. May I answer the judge's question? Thank you. I think that in the totality of the circumstances of everything that's happening, Sergeant Diaz, in his experience, as has been articulated in Terry v. Ohio, may certainly factor that in as that they seem to know something. Otherwise, why would they be standing here at this hour of the evening?
Oh, yeah, the officers found it peculiar, too, yes.
Yes, and I think-
I was just wondering whether there was some evidence to suggest why.
I understand your question now. Thank you for clarifying. No, there is nothing that would indicate that people would have been alerted through some third source of information because the communications were limited to the radio transmissions which are on a police channel as well as just the observations of the IHOP.
Can the public have access to the police channels?
That information I cannot answer, Your Honor.
Okay, thank you.
I have an
Hold
additional
on a
question.
minute, Judge Benjamin.
Yes,
has
I
some
had
questions.
additional questions. But there's no evidence in the record that they knew anything other than seeing the police pull up in front of their house.
I don't actually, it's not in the record that they did see the police pulling up in their house. That's not part of the
But-
factual record before the
But there's
court.
no evidence that they heard something over the radio and they were standing outside because there's no evidence of that.
I would agree there's no evidence that they would have heard a police radio transmission. I agree with you.
And my question earlier
Yes, Your Honor.
regarding the rear seats, the officer dispels that and says, hey, the officer himself volunteers that information. Teslas have rear-facing seats.
May I answer that question?
Yeah, of course you can.
Thank you. I do not agree with you that it was dispelled by what Officer Moran said about rear-facing seats. He said that they might have rear-facing seats. It is a possibility that warrants further investigation and certainly consideration by Sergeant Diaz, but that only furthers the reason for the Terry stop to continue.
But he acknowledges that Teslas have rear-facing seats.
I do not agree with that phrasing, Your Honor. It is might have rear-facing seats. They are not
No,
a
no, no, no,
standard.
no. I'm not saying that he's saying that this one has one. He acknowledges that Teslas have rear-facing seats.
Yes, and with the understanding that it is a possibility, that it is a design option that can be chosen, yes, I agree with that.
And that is something that he puts over dispatch.
That is something he puts over dispatch. But as I stated earlier, that is only a fact that warrants further investigation to confirm or dispel as to ascertaining whether or not a kidnapping has
That's the
taken
whole
place.
purpose
And
of
one-
a Terry stop, is to allay suspicion.
Correct, and that is a question that needs answering as part of the investigation.
And one more question.
Yes, yes, sir.
When over the dispatch, what Diaz knows when he goes to the house, right,
Yes,
is that there is a Tesla, the tag number, the address. He knows that there are kids that were in the back of a Tesla, yelled at by the parent, and that the trunk was closed in a Tesla that might have rear-facing seats.
I would make one qualification to that, Your Honor, and I'm just making sure I pull up the conversation correctly. that Your Honor said that the kids were in the back. The specific transmission was open the trunk, yell at the kids, and then close the trunk. So as if with the qualifier that the back is the trunk,
Yes.
not the back row of seating, then with
But
that qualifier,
but
yes.
I guess my point is that's all Diaz knew when he went to the house.
That's all Diaz knew before he parked his car, put it in park, yes. But he obviously learns more.
So he didn't know anything about somebody being tied up or someone being thrown in the car or pushed in the car. He didn't have, that's something we learned from Morano at his deposition.
Yes, I would agree that at the point that Sergeant Diaz parks his car in the street to get out, he does not know that information. He knows that Officer Moran has spoken to the witness, but he does not know that additional fact that Officer Moran has. I agree with you that is the state of the record.
All right, thank you.
And for these reasons, we would ask that this court affirm.
Hold on for us. Judge Bader, did you have
Oh, no, I have any further questions.
Okay. Thank you. You have some rebuttal time?
Judge. 3 points on rebuttal, Your Honors. First, we'd like to discuss everything that officers did not know when they entered Professor Hyatt's home. They did not have a description of the children. They did not have a description of the kidnapper other than that he was a black male. They did not know whether the Tesla from the vague tip was at the home, and they did not know if Professor Hyatt, the person they were speaking to, was at the IHOP that night. Second, none of the cases that defendants rely on stand for the proposition that a Terry stop alone can get officers into the home. They speak about Rivera, but in that case, one, it was not the individual who was stop's home. It was someone else's home that he entered into. So that implicates different Fourth Amendment principles. Also, the show of authority in that case happened outside of the home, as it did in Harbin. And in Harbin, officers never entered inside of the home, and that was part of the court's reasoning in that case. To say that officers could enter the home based on reasonable suspicion alone would be a sweeping new exigency, and it would undermine the probable cause required for a warrant, because then officers could approach someone on their porch, elicit just enough information to amount to reasonable articulable suspicion, initiate a Terry stop, and then use Terry as a Trojan horse to enter the
In the
home.
reasonable suspicion, the officer judges it to be confirmatory, the discussion or the confrontation or whatever it was at the home. I mean, it's not just the reasonable suspicion and they go into a home. It's a reasonable suspicion plus an investigation plus a conversation, which the officer judged at least somewhat to be confirmatory.
Judge.
Isn't that what we have here?
Judge, so there are disputed facts that go into the reasonable suspicion analysis in this case. Whether Professor Hyatt drove a black Tesla, whether a black Tesla was on the premises, and whether Professor Hyatt's behavior could be characterized as evasive and suspicious when the video shows him behaving respectfully. And a police expert testified in this case that an objective officer...
You keep talking about disputed facts, and disputed facts are when an officer gets two different stories and has to make a determination. But from the very beginning, this was an emergency announcement of kidnapping. The officers, an officer on a highway 10 miles away could hear it and is entitled to respond to that dispatch, say that's an emergency. So we start off with the notion that we have an emergency dispatch announcing a kidnapping, and then we have these pieces being put into place. But the evidence is what the officers learned as they're going along. It's not whether, in fact, it was so. As we know, what Duran learned, we know what he learned, and that's not been disputed. We know what Diaz knew, and that's not disputed. And we knew they walked up and we have the tape of the encounter on the porch. I've watched that a couple times, and so I don't think we have a battle of any kind of facts. What we have is a sufficiency of a suspicion, number one, and number two, whether a Terry stop, an investigation and Terry stop on the porch can be pursued when the person retreats into the home during the course of the investigation. And that probably is an interesting question. And you say the officers have to stop and go get a warrant. And of course, the impracticality of that is that the whole crime could have been committed and the whole purpose of a Terry stop defeated. But I understand your argument, but I don't know if you can draw fine lines and say they can conduct a Terry stop, but when the person during the course of the Terry stop and investigation retreats into the house, the officers are now without any power.
Your Honor, 2 points in response to that. It seems that there is a bit of a mashing of doctrines. So there's the emergency aid doctrine, which says that officers need an objectively reasonable basis to render emergency aid.
And they don't hide behind emergency aid. They basically have a suspicion, and they're trying to investigate and make sure we don't have a serious crime, a very serious crime. And so they are taking reasonable steps to decide whether there's a serious crime. And as they go through that process, their suspicion is not allayed, it's enhanced. We have one affirmative statement made by the defendant, there's no kidnapping here, and the rest he wouldn't answer. And so as a consequence, I mean, he could have simply said, oh, officers, there must be a misunderstanding. Those were my kids, yes, I put them in there, I have rear seats and this type of thing. But he didn't do any of that. He enhanced it and he shut his wife up. I understand your legal arguments where you're parsing the times under different doctrines, but we have a basic concept here of public privacy, which we have to honor, and the public need to investigate a crime on which the officers are investigating. And if we apply your doctrine, we're basically telling the officers they have to quit at this point. And that could have been the most serious crime. And can you imagine the uproar if there was an actual crime there? They had retreated into the house. The defendant said, there's no kidnapping here, closed the door, ran into the house, and the officers walked away. What kind of response will we get?
Judge, I see my time has concluded. May I respond? Yeah. We are not asking for this court to establish a new rule. The Supreme Court has already struck the balance. We're asking you to follow clearly established Supreme Court precedent. And after Payton, it is that officers need probable cause plus exigent circumstances to enter the home. And ultimately, the Supreme Court has been clear that it's done printing new permission slips to allow officers to enter the home absent a warrant. Accepting defendants' arguments would require this court to do just that. For these reasons, if your honors have no further questions, we respectfully request that you reverse and remand.
All right, we thank you both for your arguments, and as student counsel, you've acquitted yourself very capably, and the court appreciates it. We'd like to come down and greet counsel and then proceed to our last case. Alex, do you want to come up and open this?
I can open it.
I'm
quick.
not strong
I
enough.
can open it.
You can do it.
Yeah.
My good colleague says you can open it.
There you go.
This is embarrassing.
Oh, no. I don't mind opening. I have a hard time sometimes too.
Mr. Thompson, whenever you're ready, we'd be pleased to hear from you.
Thank you, Your Honor. Good morning, and may it please the court. My name is Jeremy Thompson, and I represent Mariel Watson. Home detention may be imposed only as an alternative to incarceration. When incarceration cannot be imposed, home detention ceases to be an available alternative. Here, Mr. Watson's maximum possible sentence was 48 months imprisonment. Thus, when the district court reached a combined sentence of incarceration and home detention of 48 months, it could go no further. Since the district court did so by imposing a combined term of incarceration plus home detention of approximately 62 months, the district court exceeded the maximum sentence by approximately 14 months.
There's no difficulty, though, in having a combined sentence of incarceration plus home detention. I don't think it would be unusual for Congress to sort of read home detention, to read any one of those two options beyond the authority of the district court. Your argument, as I understand it, is that the two things in combination cannot exceed the statutory maximum, not that that incarceration or detention is impermissible, nor is a combination of the two impermissible. They're not impermissible by themselves. They're not impermissible in combination. And the only thing that's impermissible is to use the two in a way that exceeds the statutory maximum.
That is precisely correct, Your Honor.
So in this case, home detention, under your view, could be 7 months.
Yes.
41 months incarceration. The max was 48. So 41 incarceration, 7 months home detention. That was all legal.
Absolutely.
The 14 months after that went beyond the authority.
Absolutely, yes. It's the 14 months of home detention that exceeded the 7 months of home detention that is illegal. We do not contend that the two are mutually exclusive, right? That you could impose only incarceration or home detention. We believe that you can impose both, and courts routinely do, at least certainly in my district, they routinely impose both. And there's nothing wrong with that. It's only once you get to the statutory maximum term of imprisonment.
And that comes from the clause as an alternative to incarceration.
Yes, so in our brief, we refer to that as the conditional clause, so they accept that, Your Honor.
Yeah.
And our position is that in order for that provision to have effect, there must be some limitation.
Available incarceration in order to be served as home detention.
That's correct, Your Honor, that there are many, many other conditions of probation that can be imposed as conditions of supervised release that have no term, that have no limit, essentially. You can require someone to work the entire time while they are on supervised release, for example. But to give the clause, the conditional clause, meaning, it must limit the court's authority in some way. And that, we argue, is the cap on the combined term once of imprisonment. Once you can no longer impose a term of imprisonment, then you can no longer impose home detention further. So if the court, for example, here had varied upward and imposed a 48-month term of imprisonment, then no home detention could have been imposed. If the court had done what Mr. Watson had argued below, which was vary downward and impose a lesser term of incarceration, then there would be nothing wrong here as well with imposing that full 629-day term of home detention. It's only by going beyond the combined term that the sentence became illegal.
Only going beyond the statutory maximum.
Yes, the statutory maximum for imprisonment. That's
the key, is that the sentence, however, whatever elements and ingredients it has, the sentence cannot be above the statutory maximum.
Correct. And it can only, and of those two ingredients, Your Honor, home detention, those two ingredients, Your Honor, home detention and incarceration.
Yeah.
And Your Honor, that is what the circuit.
That's the whole case, isn't it?
Yes.
Yes, so perhaps it's a good thing at this point in time, since you've got some rebuttal time as well, but we understand your argument. But I think it would be good to hear from Ms. Hoffman on this, and then you'll have some rebuttal time to whatever she says.
Thank you, Your Honor.
Is that okay?
Yes, absolutely.
Is that okay with you?
That's fine.
It's a tough case to make, isn't it?
Yes and no, Your Honor. For the record, Andrea Hoffman on behalf of the United States. Your Honors, I actually,
The United States is noble, right?
is noble?
Yes?
Yes, sir.
Okay.
I actually got asked once if the United States believes in Department of Justice believes in justice, Your Honor.
All right, that's good, too. That's like my question.
It is, Your Honor. I actually don't think that it is as difficult as Your Honors have indicated that you feel it is this morning. Congress has been very clear that when it wants, what the defense counsel is arguing for is essentially I was going to say arithmetic, but I can't get the word out correctly, a mathematical formula be found in E4, 83583 E4. And that mathematical formula is, the stat max minus this, minus that equals the amount of home confinement that can be.
It's not a formula. Basically, what Congress said, and actually I looked at some of the statutory explanations for it too. What Congress was intending is that if a judge wants to allow some form of the available incarceration to be served at home, it can do so. But it cannot, it can only do so when home detention is in lieu of incarceration, as an alternative incarceration. So if the maximum sentence is 48 months, and the judge decides to give 48 months, he can't add home detention on that. There's no more available. But in this case, the judge gave 41 months against a maximum of 48, which means there is something, and the judge could have given 7 months in addition to get up to the maximum. And that's not a formula, that's just to stay under the maximum sentence of incarceration. Because that clause at the end says only as and uses the word only as an alternative to incarceration. So if incarceration is used up, you can't have home detention. But if there's some available incarceration that could be imposed but was not, the court could impose any amount of home detention up to the max. And in this case, we have probably, 14 months over, which is not a big deal, but it's a principle, right?
Without question, we're talking about this 14-month window, Your Honor. We do not disagree. And I don't disagree with the court's premise that if there had been a 48-month sentence, we'd be in a different scenario. This court, albeit in unpublished opinions, has addressed this issue twice already.
Yeah, but those cases, you mean Hager and Moses?
No, I mean Strope and Wiggins. In Wiggins, this court had the exact appeal. It was a supervised release appeal. It had a 12-month sentence, a 24-month home confinement period, a 24-month statutory maximum imprisonment term, and this court found that this sentence was properly imposed. And under Hagar, citing Hagar and the congressional...
See, but Hagar doesn't hold that. Hagar says two things. Hagar says, number one, that home confinement at home is not an incarceration. It's a term of condition of supervised release, number one. Mm-hmm. Number two, it's not an equivalent to incarceration. There are total differences between home detention and incarceration, and Hagar made that point. But I don't think Hagar addressed the point of the imposition as a condition of supervised release, that the condition could be imposed without underlying a predicate for an available incarceration. In other words, it has to only be as an alternative to incarceration. That's the words of the statute.
It absolutely, and I think the in lieu term also works, Your Honor, but it also doesn't have to be day for day. Because the things are so different, because Hagar was so clear that incarceration and home confinement are not the same thing, and that
They're not the same, but it's an alternative to it.
It is, but it doesn't, there's nothing in the statutory provision that says it's a day-for-day alternative.
It
That
says
if,
only, what does it mean when it says only as an alternative to incarceration?
there has to be a period of which you've chosen, as a judge, you've chosen not to impose the maximum amount of statutory imprisonment that can be imposed, and instead you're going to formulate a different incarceration. In this context, envisioning it to be more considerate of the defendant. He's spending less time in prison.
But isn't it fair to think that Congress wished its statutory maximum to hold fast? That however it was exceeded, Congress, the one expression we have from Congress is the statutory maximum. And I think what Congress is saying there is, you know, if you're going to deprive an individual of his liberty, that you can only do that for a certain amount of time. You can't just stack this upon this after this and exceed the statutory maximum. That statutory maximum means that's the time you can deprive someone of their liberty. And whether you do it by incarceration or home detention, it's still a deprivation of liberty based upon the criminal process. And doesn't Congress, when it puts down that statutory maximum level, saying, okay, this is it. You can use whatever combination of home detention and incarceration you wish, but just don't go above the maximum where deprivation of liberty is involved. And that's a reasonable view of the statute, isn't it?
It is one reasonable view of the statute, Your Honor, and it is inordinately difficult to argue to you yourself, Your Honor, that Hagar said something a little different. But that's slightly the analysis that I drew from Hagar, which is obviously different than this panel is feeling at the moment, is that because they're not the same thing, we have a bucket here that's how we're going to supervise and manage this defendant after he's released from custody. Those are one set of things. And we're going to manage over here how he is handled in prison. But there's one characteristic, the home confinement provision, which has similar impacts to the defendant as this bucket does.
But Congress, they're clearly different, and Hagar makes that point clearly. They're clearly different, but the statute authorizes the judge to impose the home detention as an alternative for the clearly different incarceration, but only as a substitute for incarceration. And to give that meaning, I think what Judge Wilkinson said, basically, you know, we're denying somebody liberty at different levels because they're totally different. But Congress wanted to group those so that you wouldn't have a statutory maximum with respect to the deprivation of liberty. I guess that's what I see there, and I'm not sure how you get around that only as an alternative to incarceration. If your interpretation was correct, that clause would not be needed. The court could just simply impose home detention as it wished.
This court in both Strope and Wiggins found differently, Your Honor. Again, let me be clear, unpublished opinions, but in Strope, which was a direct appeal, you had a sentence that was 57 months with a 6-month home confinement, which would have, and a 60-month statutory maximum sentence. And this court found that that sentence was appropriate. It was also, ironically, on a motion to correct sentence, a Rule 35.
Opposing counsel makes the point that you have 3 circuits out there that are not in agreement with your position?
That's not entirely correct, Your Honor. Defense counsel relies on Hall, which is not on point. Hall is a statutory maximum sentence. He got, I'm forgetting the number right this second, but let's just say it was a 48-month sentence. He got 48 months.
Well, what are you saying? You only have 2 circuits against you?
There's really only one circuit, which is the Fifth Circuit. It's Ferguson, a fairly old case that the Fifth Circuit declined to expand upon in Polydor, and in fact, the concurrence of which very forcefully says is wrongly decided. So it has evidentiary.
Ms. Hoffman, but don't they, in Hall, go through and distinguish Hager? They refer to Hager and Hall.
They do.
And say why it's different, and they get into this whole conversation regarding alternative, the word alternative versus equivalent?
They absolutely do, Your Honor. All of which is discussion is dicta in Hall. It is not even binding in its own jurisdiction, let alone should be under this court's law, under U.S. versus Green. We shouldn't turn to the sister circuits to look for guidance if there's any controlling authority within this district.
I just have so much trouble thinking that if the court imposes a maximum sentence of incarceration of 48 months and then decides to add another 2 years of home detention as a condition of supervised release, that can be done under a statute which says that home detention can only be as an alternative to incarceration.
And I do understand that, Your Honor. The argument I can present to you is the one that I started, and I don't know if I
That's
fully...
crucial, isn't it, what Judge Niemeyer just said, that the terms only an alternative, that doesn't mean in addition to. It means as an alternative to. And there's no reason to suppose that those alternatives, that the alternatives can be juggled in a way and combined in a way that doesn't exceed the statutory maximum. But when Congress is saying only as an alternative to, and that means not in addition to, we've got to accord that language some effect, don't we?
I do understand that, Your Honor, and the only way that my view and your view can square together at all is that it's not a day-for-day calculation. Under
No,
your
it's not.
analysis, it's a day...
But if you want, your position clearly allows for home detention to be in addition to a maximum sentence of incarceration.
It does, Your Honor.
And that fails to take into account that clause. You can't have that clause at the end which says only as an alternative to incarceration. And so you're basically give no meaning to that.
I would disagree with you there, Your Honor, only in that if this had been a 48-month sentence, defense counsel and I would be making the same argument.
Well, of course, you would say that the home detention is appropriate, even if you gave 48 months.
No, I would not, Your Honor.
Why?
Because it needs to be in lieu of something. I do agree, it does need to be in lieu of something, but the court chose to not make the maximum sentence and to use its discretionary...
So the court could have given, in this case, could have given 47 months imprisonment and then imposed 2 years of home detention under your interpretation.
Yes, Your Honor.
Okay.
It would. It would.
All right, anything further?
No, Your Honors. Thank you very much.
All right.
Thank you.
Counsel, do you have anything to add?
What more can you say?
I just wanted to clarify one point briefly, which is that my friend said that Hall is not a statutory maximum case, is not a situation. Your Honors, I would disagree with that. At 64 Fed 4th at 1201, the 11th Circuit said that the district court sentenced Hall to the statutory maximum of 2 years imprisonment and added 1 year of home confinement. So it is this situation as well, where you have home confinement in excess of the combined term of of home detention and imprisonment that could be imposed. And so with that clarification, unless there are further questions from the court, we would ask this court to vacate and remand with instructions that Mr. Watson not be sentenced to more than 48 months combined home detention and incarceration.
Paul, do you have any further?
No, I'm fine.
Dee, do you have any
Oh,
further
no
questions?
further questions.
Oh, we have no further questions.
Thank you.
We thank you both, and we will greet counsel and come down and shake hands with everyone. We adjourn court. Sine die.
This honorable court stands adjourned. Sine die. God save the United States and this honorable court.